Please be seated. Thank you very much. This is a time set for oral argument in Martinez versus Scottsdale Healthcare Corporation. Our cause number 1CA CV150599. Let's begin with introductions of counsel.
Leonard Mark, Your Honor, on behalf of Appellate, and Amy Sells is with me today.
Very good.
Sean Moore on behalf of the appellate, with me is Ivan Kilbride.
Great. Very nice. Thank you very much, and thank you for joining us. Let me go over a few preliminaries. Each side has 20 minutes. If the appellant would like to reserve some time for rebuttal, if you go to the lectern and let us know how, thank you.
At both sides.
I'm sorry.
Yeah, on both sides.
Well,
We're
very
very
nice.
considerate.
Yes, thank you. Yes, we're serving ourselves with water. You don't get any, but that's okay. No, let me go back to my preliminaries here. As I said, each side has 20 minutes. If the appellant would like to reserve time for rebuttal, when you go to the lectern, if you'll let us know how much time you'd like to reserve, we'll try and make sure that we don't poach on your time and that you end up with it. We are recording the proceedings today, both audio and video, and so for those people who access the recording from an audio standpoint, when you go to the lectern, if you please could restate your name, that way the people who are listening will be able to identify the speaker. Let me advise the parties that we have read the briefs carefully. We have actually conferenced this case. We have reviewed all pertinent portions of the record, and we're really quite familiar with the issues and the arguments that you have raised and the facts that have been alleged here. So you might wish to take our preparation into account in your remarks today. And with that said, let's go ahead and begin.
Thank you, Your Honor, and good morning. Tidings of the season. My name is Leonard Mark, and I'm here on behalf of Nicholas Martinez, the appellate. I would like to reserve 5 minutes. Independent of that, I would like to think that perhaps I would end up with more than 5 minutes, but I'm usually overly optimistic, so we'll see what happens. Concerning this case, Your Honor, a number of points I want to make to the court. First and foremost is this. All parties to the case agree that Nicholas Martinez had an x-ray that indicated that he may have Hodgkin's disease, and nobody communicated that information to him. He only became aware of it a lengthy time later when he was having some health issues, and his physicians at that time requested his previous records and discovered the x-ray by Dr. Levy. The issue revolves around the concept of dual capacity. That's bandied about constantly in all the briefs. I submit to the court that the dual capacity doctrine is recognized in the state of Arizona. I submit to the court that it has never been rejected, and I submit to the court and acknowledge to the court that the cases cited in the briefs have never applied the doctrine to the facts presented at that time.
Counsel, let me ask you, what's your best case for the proposition that Arizona has adopted it as opposed to discussed it?
There's three, Your Honor. Diaz, McMillan, and Hills. I submit to the court also, Your Honor, that often in this case, in the trial level and now on the appellate level, and it's reflected in the motions on the trial level and on the appellate level, that we talk about we're talking about dual capacity in the context of it's an either-or situation, and it is not an either-or situation. It is a both situation. And as a consequence, there can be certain circumstances, as presented in this case, where an employer can not only be acting as an employer, but in addition, independent of that, in some other capacity. And in this capacity, as the court is already aware of, we submit, the appellate submits, that when Nicholas Martinez was being treated by healthcare professionals who happened to be his employers, that they were acting in the capacity of a patient-physician relationship, and as a consequence, the normal duties arose to him as would arise in any doctor-patient relationship. Scottsdale Healthcare, in the entire case, always acted as Nicholas Martinez's employer. However, at such time as it became aware as it became aware that Nicholas Martinez may have had come in contact with a patient who had tuberculosis, it undertook to treat him as a health care provider.
But didn't it do that in the context of wanting to make sure that his industrial or work exposure had not caused a work injury? I mean, for example, Mr. Martinez, I believe, signed an employee's report of an accident. It's a standard workers' compensation form, which is in the record. And so pursuant to that, he was sent, or someone, his supervisor told him, go get a skin test. I mean, this was all done kind of as part of his his work-related activities.
No doubt. You're absolutely right.
Right. Okay. So it wasn't like in some situations where the employer, for example, there's the mining case, where the mine has a whole separate section of healthcare providers to deal with the miners, their aches and pains that just happen all the time. That some may be related to their mining activities, or may be related to the fact that they just generally work hard and they have a bad back. I mean, it seems to me this is a different situation.
I submit to you that it is a different situation here. When it was determined that Nicholas could have been exposed to tuberculosis, Scottsdale Healthcare had two options. One option was to say, Nicholas, you may have been exposed to TB, and as a consequence, you should go out and get medical treatment, consultation, and whatever diagnostic treatment is necessary to determine whether you do or do not have that. The other option Scottsdale had was they could say the same thing to Nicholas, but then independent of that, say to him, we will undertake to do that medical determination for you. And that's exactly what they chose to do. They said, come see the Occupational Health Division. Do this screening that was administered by a physician's assistant. And then he was directed to go get an x-ray by a radiologist. Scottsdale Healthcare is in the business of providing health care. They are licensed health care providers from top to bottom, and the vast majority of their employees are health care providers. It's only health care providers that can administer these screenings. There's only health care providers that can order these x-rays. There's only health care providers that can interpret the x-rays. It's only health care providers who refer to Mr. Nicholas as a patient. I have with me today a copy of one of the exhibits that was submitted by Scottsdale Healthcare in support of their motion for summary judgment. And it is found in the index of record number 19, the defendant's statement of facts in support of the motion for summary judgment, exhibit number 5. And here is a copy of that document. This is the report that was authored by Dr. Levy. It was sent back to Scottsdale Healthcare. If you look at that exhibit, you will see that in the upper left-hand corner of that exhibit appears the word Scottsdale Healthcare. It's not Dr. Levy's stationery, it's Scottsdale Healthcare stationery. And the upper left-hand corner identifies Nicholas Martinez. It doesn't identify him as an employee, it identifies him as a patient. So, Scottsdale Healthcare are healthcare providers providing healthcare to Nicholas, and even Scottsdale Healthcare internally considers Nicholas a patient and not an employee.
Counsel, I need to bring you back to the cases that you claim show that Arizona recognizes dual purpose. The cases that you mentioned, two of which I've looked at while we're talking here, talk about the doctrine but don't apply it, don't accept it. And they express some pretty substantial concerns about how that could square, both here and in other states, with the exclusivity mandate of workers' compensation. So let me ask you again, because I want to understand your position. What case do you believe has squarely adopted and applied dual capacity in Arizona?
That's a two-part question, Your Honor, and I'm going to use a time-honored phrase right now. I respectfully disagree. Having said that, Your Honor.
And that's why I'm asking.
Yeah,
I want to
okay.
understand.
The cases clearly indicate that this is an acceptable doctrine. They recognize it, but they just don't apply it in the facts presented in the cases, on those cases.
Well, and again, help me understand, because I've, like I said, I've read them before, and I've read two of them again today, and they express some pretty grave concerns about the doctrine. So that's why I'm wanting to make sure I understand your position that they have accepted it, because I don't see that from the cases, and if it happened, I want to understand that.
The cases clearly indicate they recognize the dual capacity doctrine, but they don't apply them to the facts presented at that time. The difference here is that this is really almost a bright line test. You have a situation where Mr. Martinez never made a workman's compensation claim. And the reason he didn't make a workman's compensation claim is because he didn't have a workman's compensation claim. He had no ways.
Go back to Judge Thomas' question, because I'm too missing what case supports your argument that it's been expressly approved. And I'm looking at Delbridge, which says the dual capacity doctrine conflicts with public policy and is contrary to the exclusivity provision. So it's kind of important to know what case you think stands for the proposition that Arizona has recognized it as a viable doctrine given our statutory scheme. And if you want to tell us in rebuttal, that's fine with me, but I think you've kind of not answered that question yet.
Let me see. I submit to the court, as I said in the brief, the hospital has not and cannot cite any authority to support a claim the dual capacity doctrine does not apply to a hospital employer who renders negligent medical care to the employee. And we set forth with some level of specificity in the briefs a discussion relative to the three cases that I cited. Delbridge, I submit to the court, does not reject the dual capacity doctrine. And as stated in the brief, the trial court in Delbridge declined to address the dual capacity argument because the argument was not raised in the proceedings below. You have a situation where all the other cases cited by the hospital can be distinguished as they were distinguished in our reply brief.
And counsel, I understand that. And your reply brief spends a fair amount of time talking about how those are distinguishable. But the dual capacity, dual purpose is a common law concept, right? You do not find that in statute anywhere.
Correct, Your Honor.
And for that to exist, some case, if it's common law, and I believe it is, I agree, had to have acknowledged it. So it isn't that the hospital is required to show that, cases have rejected it. We need some case somewhere in this jurisdiction that says, yes, it exists under Arizona law, and I struggle to find that case.
All I can do is repeat what I've said a couple of times previously. I think it's there. But you suggest something else that warrants a comment. If it's not there, it should be there. This is an absolutely outrageous situation where this man had a situation where he had a diagnosis by a radiologist who says he's clear of tuberculosis, but you better check this out over here, and nobody tells him about it. And that's what warrants the application here. He did not have a workman's compensation claim. I maintain right now he doesn't even still have a workman's compensation claim. I suggest to this court that if we had gone and said to Scottsdale Healthcare, you have a situation where all these facts occurred, and therefore we want to make a workman's compensation claim, that the Scottsdale Healthcare would have said, oh, but this business about not informing him of what he may have had that was not related to the business about the exposure to TB was not a work-related injury. And Scottsdale Healthcare just simply can't have it both ways.
Well, do we know that they would have had it both ways? I mean, you're speculating that would have been their response.
Yes.
That was never presented.
Yeah,
to
yeah,
them.
it was, you're right. You're absolutely right. So we have this situation where we have, everybody would agree, Scottsdale Healthcare is not going to get up here and say, listen, it didn't matter that we didn't tell him, and neither is Dr. Levy. Everybody understands the consequences of this, but Scottsdale Healthcare is not accepting responsibility for it. And they should. They are a healthcare provider. They have to adhere to the standards of a healthcare provider. And as a consequence, that's why we brought the claim. Dr. Levy, in the case below, he made a motion for summary judgment. His motion for summary judgment was denied. If we don't obtain relief relative to Scottsdale Healthcare from this court, there's going to be a case that's going to go forward in the case below against Dr. Levy. Dr. Levy is going to want to assert, without a doubt, that a non-party at fault. And guess who he's going to maintain the non-party at fault is? Scottsdale Healthcare. That's going to, if that happens, that's going to provoke another special action, another session before this court, as to whether or not, given the circumstances, whether or not that he can do that. Somebody has to be responsible for this egregious act.
Isn't it, the real problem here is the exclusivity of the Workers' Compensation Act? I mean, isn't that the real problem here?
Well, I don't think...
And on this point, I'd like to shift you, because I do want to have you have time for rebuttal. I want you to tell me, as precisely as possible, what is, in fact, the injury Mr. Martinez incurred. What is his injury here?
His injury is that his treatment, as a consequence when he discovered this, was more extensive and more complicated and more aggravated because it had not been detected earlier. And if it had been detected earlier, a couple of years earlier, then the situation would not have been as grave as what it became.
Phrasing it that way, as I understand it, the injury that Mr. Martinez has alleged is that his cancer, which was perhaps in just the beginning state when he was exposed to TB, was because of the delay in revealing the X-ray results, aggravated. Now, if you phrase the issue that way, doesn't that then come squarely within the exclusivity provisions of the Workers' Compensation Act, which deals with an aggravation of a pre-existing condition?
I disagree with the court.
Okay, tell me why that does not fall within the Workers' Compensation Act.
We're in an apples and oranges situation. I'm going to lose my...
I want to make sure you have some time, so
all right.
Go ahead and answer my question.
May I make an analogy for the court? Because I've wrestled with the same question that you pose. If today I get to this courthouse, and I'm prone to get here early for obvious reasons, I realize that my notes that I prepared for the oral argument today, I left in my desk. And in a panic state, I call up my office and I say to a file clerk, a non-legal personnel, get those notes on my desk, drive them down here and bring them to me immediately. And on the way here, that employee gets hit by a driver who runs a red light, who's employed by the City of Phoenix, driving a City of Phoenix vehicle, and in the course of scope of his employment with the City of Phoenix. And he sustains a very serious bodily injury. When that happens, as an employer, Tiffany, the law firm of Tiffany and Bosco, is going to say to that file clerk, listen, you have a workman's compensation claim, and independent of that, you have a third-party claim. And we're going to undertake to represent you on the third-party claim to ensure that you get the maximum benefits possible. And we undertake to do that. And we send out letters to insurance carriers and opposing counsel, identifying that employee as our client. And we later filed a lawsuit identifying that employee as our client. But let's play the what-if game. What if through oversight, I like that word, it's better than negligence. What if oversight, I forgot about the 180-day rule, or forgot about, remember the 180 rule, but I didn't get it in within 1 year. I don't think there's any doubt in anybody's mind in this courtroom that that file clerk would have a lawsuit against Tiffany and Bosco for malpractice. There's just no doubt about it. And those facts are exactly similar to the facts what's in front of this court. I can't imagine that Tiffany and Bosco would walk in and say to a court of appeals, oh, when we undertook to serve him as a lawyer, that was just an extension of his employment, and his only claim is a workman's compensation claim. That's independent of the other thought about this issue of causation and damages, particularly damages. If he had filed a workman's compensation claim relative to this particular circumstance with this lymphoma, it would be almost impossible to parse out what portion of his bills were related to the underlying illness and what portion of the bills were related to the delay in diagnosing the underlying illness and treating it, and what portion of his work loss. I mean, it would have been impossible to parse out. It would have been an incredible, the proverbial can of worms.
Well, but that's, I mean, we sit on workers' comp cases all the time where that's the issue, the aggravation of a pre-existing non-industrial injury. And yeah, the proof may be difficult, but to say it's impossible, and that's meat and potatoes for workers' comp lawyers. I'm not sure that's your best argument.
Okay. There may be a little bit of hyperbole there, and I'll accept the responsibility for that. It still comes down what I said earlier. There has to be a remedy for this man under this egregious situation. There just has to be. And if this court does not recognize the dual capacity doctrine and apply it here, he will essentially be denied of a remedy he should have. And that's not a result that we want, legally, or for that matter, morally, or for that matter, public policy. And they should be held accountable. I've run out of time, and I will appreciate if you offer me the opportunity to at least make a few comments.
Well, let's do this. I'm going to have the bailiff, since I'm the one who instigated the additional questions, let's restore your 5 minutes. And Mr. Morey, this is Christmas time, so you get to have 25 minutes. So we'll even up the tables that
I'm not
way.
required to use all of
But
it.
you're not required to use it all, so, okay.
I never should have said tidings of the season.
No, that's fine, thank you, okay. So, there you go.
Thank you, Your Honor. Again, my name is Sean Moore, and I'm here on behalf of the Appellee Scottsdale Healthcare Corporation. We believe this is a pretty straightforward case about a man who was injured while at work in the course of his work and the scope of his work, and is now trying to sue his employer for that injury. And
Mr. Moore, let me ask you a question that has caused me some concern, and Mr. Mark has also raised it here today.
Sure.
Assume for the moment this court agrees with the trial court that summary judgment was appropriate because of the exclusivity provisions of the Workers' Compensation Act.
Sure.
Is Mr. Martinez going to be deprived of any remedy?
I don't think he'll be deprived of any remedy, Your Honor. His appropriate remedy at honor is workers' compensation. Whether or not he chooses to exercise that remedy is up to him. But moreover, as...
Let's stay with that and slow it down. If he then seeks and files a workers' compensation claim, is your client going to either say the claim is time-barred or somehow it didn't arise out of the scope of his employment? Are they going to take a contradictory, A, are they going to assert time bar, and B, are they going to take a contrary position to the position taken in this case?
Well, just right up front, I'll have to be frank with you that I don't know the answer for them. I can't speak for them. That's a bit of speculation on my part. But I have to imagine that they would not claim, at least, that it did not arise out of the employment, if that is, in fact, what we claimed and we won on in this case. But I cannot speak to what they might do with respect to the time-barred nature of the workers' compensation claim. But even more than that, I don't believe that Mr. Martinez will be out in the cold because, as Mr. Mark just talked about, he still has the underlying case against Dr. Levy for failing to correctly interpret the x-ray and failing to communicate that to him. So under either situation, he's not going to be completely out in the cold. He still has the underlying case ongoing. As we mentioned in our briefs, we believe that there are 3 independent reasons why workers' compensation should apply in this case. Mr. Mark did not talk about that in his opening. The plaintiffs did not really discuss it in their reply brief, so I will skip over that portion unless the court has any questions for me and go right to the dual capacity doctrine.
Well, let me ask, what, and it's a case law concept, but what was the industrial injury here?
Well, the industrial injury could be considered either one of 2 things. One, it could be considered the accidental exposure to tuberculosis, or it could be considered the failure to communicate the x-ray test results. And I think that there's precedent for both of them. I think that the exposure to tuberculosis is more straightforward, but as far as the communication of the x-ray test results, you look at a case like Dugan, for example. They considered an industrial accident to be the blocking of a 911 call and then the failure for their in-house medical team to respond within time.
Is there any, and Duggan does say that,
Yeah.
Without citation or anything, but it says that. Is there any case law that sort of follows that? Because when you think, and again, industrial injury is a case law concept. You don't find it in the statute. You find accident in the statute.
Correct.
You can envision a world where blocking a 911 call system wouldn't be an industrial injury, and I struggle with that some. I completely understand the exposure to tuberculosis or an individual believed to be a carrier as being an industrial injury. Mm-hmm. When it gets further away from something like a broken bone or a communicable disease or something like that, I struggle with the application of that concept, and that's why the failure to report being an industrial injury, I struggle with.
Well, I think that the test comes straight from the normal standards that you would apply to any workers' compensation case. Does it arise out of the employment? Does it occur within the course and scope of the employment? And does it cause...
We need an industrial injury first.
Or we need an accident first.
Right.
Well, the industrial injury, he's claiming, as we discussed in our briefs, the industrial injury requires some sort of physical change within the body. The plaintiff is certainly claiming a physical change within the body here because he's asserting that his cancer got worse due to this lack of detection, and therefore it created changes
If that's the case, is Duggan wrong? Because as that was described, the industrial injury, the blocking of the phone system, was not a physical change.
No, but
in the body.
It did cause a physical change, which was allegedly the brain damage which was caused by...
And I understand the product of
Right.
that, but it describes the industrial injury, if I'm remembering right, as the blocking the system. The inability to reach emergency assistance constitutes, actually that uses an accident as opposed to industrial injury. But so it's your position that industrial injury requires some physical change to the individual.
Well, I mean, if there's no physical change to the individual, if there's no injury suffered, then there's no industrial injury. I think that I can agree on that point. But I also think that the Dugan case, or Duggan, if that's how it's pronounced.
I claim no expertise on that.
Either way, I believe that case is still good law. It may have been inartfully worded if they said that the blocking of a 911 call was an industrial injury. But I believe...
And to clarify, they called it an accident.
An
that
accident.
was the accident. And again, I'm not sure that those are synonymous terms, but...
And I'm not sure that they are either, but I think that the understanding in either case is that the blocking of the 911 call caused an industrial injury, and that's why it was compensable.
But to get back to your 2 possible industrial injuries, that definition then excludes the second, the failure to communicate. It would, using that test, it would be the exposure to TB. That would be the industrial injury in this case.
Well, the injury would be... because the exposure to TB didn't actually cause an injury. It turns out he didn't actually have tuberculosis.
I understand that. But so help me, and then perhaps I'm taking us to a gray, foggy place, but I thought I heard you say that 2 things, that there are 2 possible industrial injuries, the exposure to TB or the failure to communicate the results of the X-ray.
Correct.
But then that the industrial injury had to be a physical change in the body. It was what I wrote down. Now, perhaps I got that. Okay. help me understand how the failure to communicate could be the industrial injury if it requires a change in the body. I can't get there.
Well, I mean, the failure to communicate, I mean, you know, when someone falls down a flight of stairs, the act of falling down the stairs isn't what an industrial injury is. It's the harm that's caused by falling down the stairs.
Well, and
so,
I think that, to me, I think we're beginning to conflate terms, because to me the threshold question is, was there an accident arising out of it in the course of employment? That's the statute. That's what we start with. And then we know Dugan interprets accident very broadly as an accident includes any unexpected injury-causing event that is work-connected. So I think to some extent we have to be very careful in the terminology, because we're defining the statutory term of accident through an injury-causing event that is work-connected, and I would think an injury-causing event that is work-connected is broad enough to include the failure to communicate findings.
yeah, and that's exactly our point, Your Honor. We believe that since plaintiff is claiming that he was directly physically harmed by this failure to communicate, and that this was an accident that was allegedly caused by a lack of due care by Scottsdale Healthcare, that this is in fact an industrial accident. I hope that clarifies what you were looking for, Your Honor.
Thank you.
Okay. So if there are no further questions, I'll move straight on to my analysis on the dual capacity doctrine. So as we've discussed in the opening here today, plaintiffs spend a large portion of their brief trying to distinguish a lot of cases in Arizona where they say the dual capacity doctrine doesn't apply, but we might apply it in some other case. And it's been on a broad range of subjects. In the Hills case, the plaintiff claimed that the defendant was acting as the producer of a defective lift. In the Allen case, plaintiff claimed that the defendant was acting as a producer of a defective harvester. In Diaz, the plaintiff was claiming that the defendant was a negligent rescuer. In Dugan, the plaintiff claimed that the defendant was acting as a guardian of quick and accurate delivery of medical services. And in all of these cases, the court found that the dual capacity doctrine should not apply. And plaintiffs spend a lot of time distinguishing all of them, but what they never tell us is why the dual capacity doctrine should apply in this case, why it would be good policy for the dual capacity doctrine to apply to medical service providers whose employees get injured. And I don't believe that there is a good reason for that, Your Honors.
And the basis of that is?
And the basis of that is what the dual capacity doctrine is really trying to get at is it's trying to test the nexus between the injury and the employment. Essentially, if the employer is operating in a dual capacity, that means that the injury that was caused wasn't sufficiently related to the employee's employment for workers' compensation to apply. But that's what our existing workers' compensation law already tests. That's what the arising out of and the within course and scope test is already there for. If we put in this dual capacity doctrine layer in certain specific situations, it would only confuse a well-established and well-understood doctrine by adding in just layers of confusion and not knowing. I mean, we've seen in these examples all the various areas that people have claimed application of the dual capacity doctrine, and if we were to adopt it in this case, people would just try and use it again and again and again. And that would only create confusion and would not be good policy overall.
Well, and is that also why Delbridge, you think, talked about it being contrary to the exclusivity provision? I mean, we have to be faithful to the statute no matter what we do. And so at some point you put such a hole into the statute's exclusivity that it becomes...
Right. I mean, the only time that the dual capacity doctrine would be particularly relevant is when an injury would already be found compensable under existing law, and then the dual capacity doctrine would swoop in to say, no, this is actually not compensable, right? So at the point that the dual capacity doctrine says compensable injuries are now no longer compensable, I agree completely that it would go against our existing law, it would go against the legislative intent in passing the Arizona Workers' Compensation Law. And that's, I believe that we had a quote from Switchenberg that basically talks about, or this is Hills, excuse me, the endless imaginable situations in which the dual capacity doctrine might apply, how its application in this state would cause large holes in the exclusivity clause that was clearly intended to protect employers from lawsuits by their employees who were injured on work, injured while they were at work. I mean, if If it's the case where a certain injury doesn't have a sufficient nexus between the employment and the injury to be related, then that will already be caught by the arises out of and within the course and scope test. I don't see why the dual capacity doctrine needs to be adopted on top of that. And even if this court feels some lead to go down the dual capacity doctrine route, I would posit that in this case in particular, Scottsdale Healthcare was actually acting as an employer. Mr. Martinez received a note in his work mailbox saying you were potentially exposed to TB while you were on the job. He filled out an employee injury form. He received a form instruction from his employer telling him to report to occupational health during work hours to receive treatment. He received that treatment for free on his employer's premises. You know, he was just following the orders of his employer to receive this treatment, and it's part of a healthcare employee's job to remain healthy on the job, to not spread communicable diseases to those who might not be in great health. So I believe that Scottsdale Healthcare was acting as an employer in this particular case, even if this court decides that the dual capacity doctrine might be applicable theoretically somewhere. I do not believe that it is applicable here. The last thing I want to talk about is potential waiver of the dual capacity doctrine argument. I know that plaintiffs argued the dual capacity doctrine below, but I do not believe that their opening brief sufficiently raised the dual capacity doctrine. That phrase only appears once. They cite it without any real case support saying that it should apply, and they use it as an example to show why there might be a question of fact in this case, rather than saying it should affirmatively apply and should exclude this injury from workers' compensation. And I don't think that they really developed that argument as fully as they could have. I mean, if you take their opening brief.
Let me ask you.
Yes, Your Honor.
And I haven't committed your answering brief to memory, but I've read it and spent quality time with it. You address the dual capacity doctrine, don't you?
Yes, we do.
Okay.
Yeah.
You weren't surprised.
Right. I understand your waiver argument, but that, to me, kind of undercuts the waiver argument. But I'm happy to be proven wrong on that point.
I can understand that, Your Honor. I guess my point on this is if you were reading the opening brief on its own, I'm not sure that there's enough for the dual capacity argument to decide on that fact.
And that's fair. And I will avow to you that we don't do that. We read all three briefs.
Of course, Your Honor. Unless the bench has any more questions for me, I'd save the rest of my time.
Thank you very much.
Thank you.
There was an attorney in Phoenix. Hey, I'm going down East Washington one day, and I see a license plate in front of me on the back of a car, and the license plate read, "Yes, but." And when I saw that phrase, I knew immediately it must have been a trial attorney driving that vehicle. Yes, but. These things. Number one, relative to the questions that you talked about earlier about what's in Martinez and what's in Hills, I know that we said in our brief, the opening brief relative to Martinez, if an employer acts not as employer, but instead in a second capacity that imposes separate obligations independent of his responsibilities as the employer, and the employer's negligence in this assumed role causes injuries to its employee, the dual capacity doctrine applies to allow a civil suit for damages. And again, I'm citing Diaz and Hill. Independent of that, I submit to you that it is black letter law of this state that workmen's compensation laws should be liberally, remediately, and in a manner ensuring the injured employees receive maximum available benefits. Now, if that's the black letter law of this state, then it is the intention of this state that when the circumstances arise that warrant it, then you have to do that which is necessary to protect the worker. when everything is said and done, the people who are treating Mr. Martinez are healthcare providers working for a healthcare provider, and at the same time, the incident for which we complain has nothing to do with the exposure to TB. We're not complaining that he was mistreated relative to the exposure to TB or the diagnostic treatment relative to that. Any of that fell below the standard of care. That's not the issue. It's when the radiologist determines that there's a possible other problem that should be explored and nobody tells the patient. That's what the issue, that's what this is all about. Independent of that, a minute ago, the Dugan case was discussed. The fact that Mr. Martinez was not told about something else when it was apparent to the radiologist is not a work-related incident. It had nothing to do with the TB screening. It just didn't have. It's a total and complete separate act, and it should be considered as such. And if it is...
Let me read you the part of Dugan that I think is, that I'd like you to address. It's pretty broad language. It's interpreting the term accident in the workers' comp statute, and it says an accident includes any unexpected injury-causing event that is work-connected. So aren't you alleging that the injury-causing event here is the failure of the hospital to disclose his X-ray results?
I'm suggesting to the court that this is not a work-related act.
But can you answer that question? Is the injury-causing event that you're alleging their failure to disclose the X-ray results?
The failure to disclose the X-rays result as related to something independent of the TB.
Right, okay.
That's my position.
Okay.
It was mentioned...
Let me ask you a question on this in relation to Judge Downey's follow-up. If the facts were different here, and instead of the nondisclosure, the radiologist had inadvertently maybe burnt Mr. Martinez in the course of the X-ray, overexposed him to X-ray, so he suffered some type of skin burning or something like that. Okay.
Yes.
There'd be no question that would be an industrial injury, correct?
I think so.
Yeah, I don't think there'd be any question.
I haven't pondered it.
Well, yeah,
my pardon the expression, gut reaction is you're right.
And that was my reaction, too, when I was thinking about this. Here, the injury is different. It's a nondisclosure. But isn't it somewhat analogous in that a radiologist arguably acted negligently in failing to disclose the results of a X-ray? My hypothetical is the radiologist acted negligently in conducting the X-ray. What's the difference for purposes of arising?
But the X-ray arises out of and because of the tuberculosis and the failure to disclose some other potential life-threatening illness does not arise out of that.
Okay.
You don't have the benefit of Dr. Levy's deposition, but if you did, you would discover that Dr. Levy maintains, I discharged my obligation. This goes back to the McCarver issue. I discharged my obligation. I told Scottsdale Healthcare, and I had no additional obligation to contact Mr. Martinez at all. That's what Dr. Levy's position is. Well, we have a situation here. When we filed this lawsuit, we named both Scottsdale and Levy. And why? Because it is obvious that Dr. Levy is going to blame Scottsdale Hospital. He's going to say, I didn't do anything wrong, but if something was done wrong, it wasn't me, it was Scottsdale, and Scottsdale is going to say the same thing the other way. He mentioned something about the briefs, about waiving some arguments.
I don't think you need to address the waiver issue.
I don't have any additional comments unless the court has some comments.
Well, we don't, and we do appreciate your patience with us today, and we also appreciate your briefing and your argument. We'll take this matter under advisement and issue a decision in due course. Again, thank you very much.
Thank you, Your Honors.